Thank you. Next witness, please.
Good morning. My name is Farah McDade Ting from the California State Association of Counties. Thank you for letting us speak today. I want to thank the Assembly member as well as the sponsors and the Assembly member's staff for working with us on this bill now 2 years in a row. We appreciate it. Regretfully, we are still opposed. I do want to say that the LPS system is based, as Trent mentioned, on the clinical recommendation of a mental health practitioner who says this person could possibly be gravely disabled as a result of mental illness. And that's where the recommendation for an LPS conservatorship comes through currently. We agree with the committee analysis that, yes, very few people who, under this scheme, who are recommended by the probate judge for an LPS conservatorship would fall under LPS conservatorship. And that's our point, actually, is that the judge, even with the consultation of a medical professional, is coming from a different perspective than a person who has touched the mental health system. LPS conservatorships come through the mental health system currently. And again, because they do severely curtail the rights of the person who is conserved, we feel that the current LPS statute that has the rights and protections and due process for those folks, we think that keeping it on the mental health system side is the smart way to go. And I would also say that, yes, under this scheme, again, we agree that few people would actually qualify for the LPS conservatorship, but what it would do is require the public guardians to investigate each and every one of those people, and that's where the costs come in. We're not concerned about the costs of the LPS conservatorships because, again, we feel that very few people would qualify. It would be compelling the public guardian to do that investigation and to do it within 30 days. So those are our main concerns on that. I'd also say, again, that it's not the tool, the LPS conservatorship is not, again, meant as a tool for the court system. It's a tool for the mental health system to best serve the folks that need the most help. And lastly, there is no such thing as an early entry into the LPS conservatorship system. You have to be gravely disabled, meet a very high bar. It is not a preventative nor necessarily a treatment-oriented conservatorship. It's to help someone who is in grave danger to themselves or others, who has no assets, no family, no friends, who cannot care for themselves. All of these have to be in place to be conserved under the LPS system. And many of the people in the probate system do have family and friends who can help them, do have some other resources that perhaps they can draw upon. If they are severely mentally ill, we contend that they would touch the mental health system, and if they are in need of that mental health treatment and or are gravely disabled, then the LPS conservatorship recommendation would be made through that door. So with all due respect, we continue to oppose, and thank you for your time.
Thank you. Next, please.
Good morning, Mr. Chair and members. Adrienne Shilton, representing the County Behavioral Health Directors Association. We represent the public behavioral health authorities in counties across the state. We also regretfully are opposed to this bill for many of the same reasons articulated well by both Farah and Trent. Just to reiterate again, AB 193 would circumvent the current process that is at place in the county mental health level to refer folks for LPS conservatorships. So we feel that a probate judge who's lacking in clinical expertise potentially could refer folks for LPS conservatorships who do not need them. So for these reasons, we remain opposed to this bill.
Thank you. Any other witnesses in opposition? All right, seeing none, I'll bring it back to the committee. Questions? Comments? Mr. Gallagher?
Well, I thank the author for bringing this. I think it is an important tool to kind of catch those people who might be slipping through the cracks. There does seem to be an issue with, as a former county supervisor, I can appreciate unfunded mandates. We're a requirement that we're going to do this. So, is there funding attached to this where the counties would be reimbursed for, additional investigations that they might have to do?
Well, I think what's important to keep in mind, Mr. Gallagher, is this bill doesn't add any new powers to a probate conservatorship. It begins the process. So it's one person, a judge, who's in the position, who's viewing this case in its widest form to make a recommendation. So what would the cost be of that? You have a judge who's an employee already being paid, and you have a county employee who's being paid. So, I don't know, what sort of unfunded mandate is it when you're talking about somebody making a recommendation who's already hearing the case? I think it's a little bit of a stretch to say that that's, this is going to be a huge burden on counties. Secondly, it is a very small number. I mean, they point out correctly. I agree with the opposition there. It's a small number, but this is a number that is severely mentally ill, very severely. You talk about cost to counties. As somebody who has spent a significant portion of my professional career working both in city government and then working with the severely mentally ill homeless, the cost is huge to do nothing. So I can't tell you what this would mean for the rest of the state, this process, but I can tell you what I did in San Diego saved San Diego a tremendous amount of money working with a very small number of severely mentally ill. So the net result of this, if this were to go through, in my belief, is what happened in San Diego would be clearly able to be replicated throughout the rest of the state. This would end up saving local governments a tremendous amount of money.
Yeah, I think you make a good point, and I also agree. I think this is going to be very limited in its use. I don't see judges you making this recommendation in every case. It's going to be a very limited amount of cases.
You're correct.
But there's a motion, which is the recommended motion is due pass to appropriations. So we do have a motion. Is there a second? And we have a second. Well, Mr. Mainshot, maybe you could address the concerns of the opposition. It's not that the judge, the conservators are there, but I think what the concern is that because this is an individual, the judge, who is not currently the one making the decision about moving somebody into an LPS conservatorship, I think the fear is that now there will be more of those investigations, and that is one of the cost drivers. I'm supportive of the bill. Yeah. I understand that issue, but having more investigations, I think, is a good thing to make sure that we're really vetting and looking at who needs to go into those services or not. I also like your approach here, where you do have a judge with the broader perspective, kind of making that decision, but hopefully with the medical professionals, with the others there to inform them, because a judge is not a medical professional. That's why we go to law school and not medical school. Correct. But they're the ones with overall charge of the outcomes for that individual. So if you could address what those concerns are, because they are well considered, and I know the conservators are concerned about impacts to them because they take their role very, very seriously.
Agreed. I mean, I think, Mr. Chairman, you make a good summary of it, is the judge is somebody who's looking at it from a broad view, because they're looking at this individual kind of in his or her entirety. They're making a recommendation for an investigation. These are people that I would say that have slipped through the cracks, that deserve some sort of investigation. Now, again, ultimately, it is going to be done by somebody with mental health training. It's not going to ultimately be done by the judge. It's going to be done by people who work in mental health. I would add on that still ultimately, for an LPS conservatorship to actually exist or occur or be granted, is the highest standard of proof that we have. It's beyond a reasonable doubt. So there's all these safeguards in the system, I think, along the path, but how, as particularly those of us who come from local government who have seen, how do you handle those people who are so severely mentally ill? Beyond it is a very small percentage. Beyond that, I would say that their case, and what this bill does, it makes sure that they get some sort of investigation, the opportunity to have some sort of help. If they don't meet any of these requirements along the way, either through investigation by mental health, or if they don't meet the very highest standard of proof, the same standard of proof we have for criminal cases, then the conservatorship isn't going to happen. So I believe that safeguards are in the system to make sure that they're being protected, and at the same time dealing with people who really need assistance. And it is, one of the points that was raised is this doesn't solve the entire problem. Of course it doesn't. But I would say that solving part of the problem, particularly for these small percentage that are so severely mentally ill, is a huge first step.
Thank you. Mr. Wagner?
Well, I mean, it looks like Mr. Smith would like to respond, and I do want to make sure he has the opportunity to address the question.
Ask him a question.
If I'm, what do you think about what you just heard?
Well, first of all, I just kind of a response to many of the comments. There's nobody in this profession, and I'm talking about the public guardian, who cares more for these individuals and trying to, I mean, they are on the front lines in caring for these people. And they would have no problem doing more and more of these, but as I've discussed with many of you in the past, it is just literally the system is collapsing on them. So even under the current system without this bill, they are caring for more and more people without any more resources. And so I've stated it here before, the public guardian services is not only is it an unfunded mandate, this service receives 0 state dollars. It is all contingent on the counties to fund the systems, and some counties do a better job of funding them or not, or not. Even under realignment, when there was money dedicated to law enforcement, the courts, whatever, there was no money specifically allocated for this type of service. And in fact, our services have gone to the state mandates claim hearing and were rejected because technically the services, the public guardian in code is a may rather than a shall. So in other words, counties may provide this service, and even though all 58 counties do provide the service, they're not eligible for an unfunded mandate claim. So I guess the point I'm making is, again, it's a very, the intent of the bill is very good. We don't necessarily disagree with it, although, again, having a judge rather than a mental health professional initiate it, we do feel like there will be more and more investigations of which we will not be able to do an adequate job doing, and maybe from that only a small number will end up in an LPS. But it doesn't mean that the number of investigations will be a small number.
All right, but address Mr. Mainshine's point, if you would, please, that having been on the ground, having been involved intimately, as we know he was when he was on City Council, at the end of the day, this is a cost savings provision. If well, that's his contention. You address it, please.
Yeah, and so the question I have is, and again, not knowing the specific individuals he dealt with, but if there is someone, and I believe we're talking maybe a homeless person, and the police pick them up, if the police, while that person is incarcerated, there are different holds, 72-hour holds, they can begin the process of saying, you know what, maybe we better have a mental health professional look at this individual, and based on that, there can be some determinations as to whether this person is mentally ill under the definition of the law, or someone who has dementia, or some other facility. So we don't necessarily argue that maybe there would be cost savings if you kept this person off the street and police doesn't have to keep picking them up. But no matter what, this person is going to need very serious, expensive care, whether it's through LPS or some other system.
And I'll just comment, and I think in your comment earlier that you don't disagree with fundamentally trying to do something in this space, but I think in California we have a real issue in that we want to and should be providing services, but we haven't figured out how to do that across the board in an effective manner with respect to the conservators. And every time we look at trying to deal with the homeless, and I laud Mr. Mainshine's work in San Diego, it becomes very politically charged, and we get off track with the notion that there are some acute issues that we need to address and give tools to local governments to be able to work with those populations in a humane and rational way, which ultimately becomes those cost savings. But the more we're not looking at the problem or don't recognize it, and so the AB 109, the realignment that we did, was a broad brush. Nobody wants to take this narrow piece of the folks who are severely mentally ill living in our communities because it's hard to do and it's expensive to do, and it falls to the guardians, it falls to other parts of the system to pick that up. I don't mean to put words in your mouth, but I know that that's the frustration. I know that's a part of it. If all else were equal, we should be doing these kinds of programs, really looking at it, but I think there's a fundamental piece that we all should take very, very seriously at the state level about looking at the conservatorship program, looking at local tools for governments to be and agencies to be able to deal with the homeless that they have and have those resources. Bigger picture, I think there's a lot going on in there. I'm recommending do pass because I do appreciate this part of it. I completely understand the concerns around it, but I think your concerns are fundamentally the larger concerns that we have to look at and so far have not looked at the state level very responsibly.
And I
appreciate that.
I would, Mr. Chair, I would agree. I guess fundamentally what we're kind of advocating here, if you're going to move forward with this bill, that at some point there needs to be a larger picture approach to this entire mental health system and who's involved, how it's funded, et cetera. Because there, as I started my comments, there are a lot of deficiencies in the systems, a lot of gaps, and we fully admit, as the author has stated, that there are people who should be getting treatment who maybe aren't. The question is how do we go about it? And it's going to take more than just this bill. It's going to take a lot of other effort and funding and more people paying attention. So,
I completely agree. All right, Mr. Mainshine, I'll ask you to close.
Thank you very much. This is an important step for people who have really fallen through the cracks in this gap in treatment, and I think it's something that would really have a profound impact on the potential for a profound impact on these individuals' lives, and also for huge benefits for local governments as well. And I would respectfully request an aye vote. Thank you, Mr. Chair.
Thank you. Call the roll, please.
Stone?
Aye.
Stone, aye. Wagner? Wagner, aye. Alejo? Chow? Chu? Chu, aye. Gallagher? Gallagher, aye. Garcia? Garcia, aye. Holden? Mainshine?
Aye.
Mainshine, aye. O'Donnell?
Your bill is out. Thank you. And thank you for the debate on this issue. It's an important one. Right. I see Mr. Levine, so we will go to item number 8, AB 501. Good morning.
Good morning. How are you? Thank you, Mr. Chair and members. I'd like to start by thanking the Chair and the committee staff for working with us on this bill and accept all of the committee amendments as proposed. The bill is a simple premise that addresses a complex subject, environmental data. It might not sound exciting, but it is hugely important. Our laws for managing resources require that the best available scientific information is used to inform decision makers. As the National Academy of Scientists states, data sharing and data transparency reinforces open scientific inquiry, promotes new research, improves data measurement and data collection, encourages multiple perspectives, protects against faulty data, and enhances the climate in which scientific research confronts decision making. Perhaps nowhere this is more important than in the Delta. It is the hub of the state and federal water projects. It is an environmental treasure and the largest estuary on the West Coast. But by some estimates, there are over 100 different state, federal, local, and non-governmental entities conducting scientific analyses in the Delta. In 2009, we created a Delta Science Program and a Delta Independent Science Board to help inform Delta water and environmental decision-making. It seems only logical that we should ensure that when the state funds Delta research, we make it available to the Delta Science Program and other scientists. I ask for an aye vote.
Thank you. Your witnesses in support.
Hi. My name is Greg Gibson. I'm the president of Recreational Boaters of California. We're a nonprofit advocacy group representing about 80,000 boating families statewide, 80,000 voting, tax-paying families, I like to remind people. You might think, why do boaters care about a bill like this? And I will say, as a recreational organization, people that want to go out and take a boat ride, to have a sail race, put on a fundraiser for Make-A-Wish or whatever, we find ourselves being one of the most highly legislative and regulated recreational endeavors out there. Whether it's the paint we put on the top of the boat, the paint we put on the bottom of the boat, where we boat, how we boat, when we boat, it's all governed by regulations. We are hugely involved in dredging issues, water hyacinth here in the Delta, BDCP, ethanol in the fuel, and all of these are driven by scientific endeavors. And our mantra, boaters tend to be a hard-headed, stubborn kind of bunch, myself included, but we are all driven by facts and science. And a bill like this, which is going to help us get the distribution of the facts and the explanation of the science out there to be reviewed, is, I think, hugely helpful to our concerns as we go further in our regulatory efforts. And we urge an aye vote.
Thank you. Any other witnesses in support? Seeing none, any witnesses in opposition? Seeing none, I'll bring it back to the committee. Questions, comments? We do have a motion and a second. Several motions, several seconds. Mr. Lean, you may close.
I respectfully ask for an aye vote.
Call the roll, please.
Stone?
Aye.
Stone, aye. Wagner? Wagner, aye. Alejo? Chow? Chu? Chu, aye. Gallagher? Gallagher, aye. Garcia? Garcia, aye. Holden? Mainshine? Mainshine, aye. O'Donnell?
Your bill is out.
Thank you very much, Mr. Chair and members.
Seeing no other authors, Mr. Gallagher, quick. Jump out there. Claim the spot. So this is item number 6, AB 285.
Thank you, Mr. Chairman and members. Today I'm proud to present AB 285. This bill would modernize the legal document assistant registration requirements to allow LDAs to better serve their clients. And one of the big reasons I wanted to bring this forward is to really highlight the asset that I think the LDAs bring to our justice system. These are people who are really helping provide low-cost and increased access to our judicial system. And, I think the statistic is somewhere around 80% of persons in family law cases are unrepresented, which means they're trying to navigate this process on their own. And I've seen it myself in court where frustrated parents or frustrated people come into the court, they haven't filled out the forms properly, and the judge has to say, hey, look, you got to go back and do this right. And they're frustrated by the process. But they can't afford to hire an attorney to help them navigate that process. So a lot of times LDAs are filling what I think is a very needed gap in the justice system, helping these people fill out these forms so that they can get access to our courts. So what this bill does is really kind of help LDAs, make it a little bit easier for them to operate. As I said, LDAs assist with divorce and other family law matters. They assist in domestic violence restraining orders, conservatorships, adoptions, and other matters. They play a critical role in legal self-help by aiding underserved clients who may not be able to afford the high cost of attorney's fees. The two main things that AB 280, and I also want to say I am accepting all committee amendments, and I want to thank the chairman and the committee for working with me on this bill. The two main things this will do is AB 285 will require that the expiration date to be on the mandatory contract for self-help service, but removes it for other materials so that an LDA does not have to replace their materials every 2 years. Because right now under current law, every 2 years they have to re-register and their materials would have to change accordingly. So this allows them, they still have to keep it on the mandatory contract, but for all other materials they can remove it. I'm also accepting the committee amendment to clarify that the registration date must still be listed on electronic materials such as the LDA's website. Current law also requires the assignment of a new registration number if an LDA registration renewal is late, even if the period of non-renewal is voluntary. This requirement increased costs by forcing LDAs to discard all their old materials listing their old registration number. So this would allow them to keep that registration number and avoid that consequence. Additionally, multiple registration numbers make it more difficult to track the history of unscrupulous individuals and is deceptive to the public as to how long a registrant has been practicing. So keeping that registration number actually helps the consumers and the public as well. So I'm also accepting the amendments to keep the registration period at 2 years. I did originally propose 4 years, which is what it is for a notary. I'd like to continue to work on that in the future, but I'm accepting the amendment to keep it at 2 years. The bill has no opposition and is supported by the National Federation of Independent Business, Responsive Law, and the Association of Legal Document Assistants. Today with me to testify in support of the bill is Ian Duncan, President of the California Association of Legal Document Assistants, Ken DeVore from the National Federation of Independent Business, and I believe we have one, and Carolyn, the Treasurer of the California Association of Legal Document Assistants. Thank you.
Thank you. Your first witness, please.
Thank you. My name is Ian Duncan. I'm the president of the California Association of Legal Document Assistants. As Mr. Gallagher described, the vast majority of litigants, especially in family court, are self-represented, upwards of 80%, and 90% of domestic violence litigants in family court are self-represented. Legal document assistants are there to help those self-represented people who are in need across our state, with divorce, restraining orders, conservatorships, and other such matters. The California Association of Legal Document Assistants is a statewide association of LDAs whose mission is to provide high-quality education through a standardized curriculum to ensure that those self-represented individuals get the benefit of assistance from an educated LDA workforce, an educated and competent workforce. This bill streamlines and modernizes our registration requirements, and we support it. Mainly, it makes it improves our ability to help the people who need our help, which we do every day.
Thank you. Next witness, please.
Of the committee. My name is Carol Ludlow. I'm a legal document assistant from Santa Clara County. I'm also treasurer of California Association of Legal Document Assistants. I want to concur with everything that Ian said, but I wanted to add also that our mission, the California Association of Legal Document Assistants, our mission is education, but we actually mandate education for our members in order to be members of our association. I wholeheartedly support this bill, and I thank you for your time.
Thank you. Next witness, please.
Thank you, Chair and members. Ken DeVorth, the National Federation of Independent Business, and I want to thank you for working with the author on this bill. From a small business perspective, these folks are small business owners, and having to throw out all of your documents, your stamps, everything you've created every 2 years and buy new ones just is one more business cost, and bringing it into the modern era is we strongly support it. Thank you.
Thank you. Any other witnesses in support? Seeing none, any witnesses in opposition? Seeing none, I'll bring it back to the committee. We do have a motion. The motion is due pass as amended to local governments. And as we talked to Mr. Gallagher about this bill, I think this is really susceptible because I understand the issue about the multiple registrations. And in a modern era where somebody will be practicing county to county to county, maybe we need to figure out a statewide database or some easier way to be able to do that. My goal is just to make sure that somebody is using the services has easy access to, and they're going to likely go to their county, go to some central place to figure out who's doing that and look for that registration. So I mean, as we continue to work on this, I think there are probably easier solutions to be able to address the issues that were brought forward, but I appreciate you working with us on it.
Well, thank you, Mr. Chairman, and I do think that's something that we should work on. This is kind of a first step, but I think ultimately getting rid of this practice where they have to register in every county is kind of a burdensome process. And with today's technology, we should be able to come with a centralized database. And talking with the industry, they're actually willing to create a searchable database of all LDAs. So I think in the future, that's something that we should really try to work on. That'll be better for the consumers of the service, but also for the LDAs themselves.
Okay. Thank you. Any other questions, comments from committee? Seeing none, can I take that as your close?
Yes.
Thank you. Thank you. Call the roll, please.
Stone.
Aye.
Stone, aye. Wagner.
Aye.
Wagner, aye. Alejo. Chow. Chu.
Aye.
Chu, aye. Gallagher.
Aye.
Gallagher, aye. Garcia.
Aye.
Garcia, aye. Holden. Mainshine.
Aye.
Mainshine, aye. O'Donnell.
Aye.
O'Donnell, aye.
All right, that bill is out. Thank you. Mr. O'Donnell, are you ready to present your bill? All right, so we'll move to item 10, AB 552.